Sorry, some administrative work. Yes, yes. Want to make some submission? Yes.
I beg to mention item number 4, Your Lordship. Similar cases pending in division bench, Your Lordship.
Similar cases are pending before division bench.
Yes, Your Lordship. Serious matter, Your Lordship.
Wait for a few minutes. We'll just see and then.
For admission, item number 1 and 2, part matter.
Mr. Gugoi,
Lordship,
last occasion we made a
Lordship, I have to address before your Lordship whether
That,
the action taken by us is justifiable or not. Whether it
some
permit or not.
relevant judgments also, if you have any.
Lordship, I will just reading Lordship. First of all, Lordship,
The
Whether-
report to Asnike Vitro. The record, please proceed. You have the records with you, no?
Yes, madam.
Lordship. Where the records, Lordship? Where the records?
Just a minute. Let us
Lordship.
go back to the. Sir Ahmed, where is the advertisement?
Malala, page 35.
Mr. Ahmed, can you show us the form of the application?
Hello.
Form of the application, because it was in the website, right?
Yes,
Do you have a copy of your application?
no, madam.
Yes, Mr. Gogoi.
Lordships. May kindly come to page 50, annexure 18
Hmm.
of WBC. WBC Lordship 1 to 6 is 22 Lordship.
Hmm.
Here the Lordship, with reference to the subject and letter cited above, I am directed to inform the government of Assam in Higher Education Department regret to consider a proposal for appointment of assistant professor in provincialized college who are from outside the state, and you are therefore requested to take necessary action, Lordship. The rejections, Lordship, on the ground is that, Lordship, the petitioner is the outside the state, Lordship. Whether that can be permissible under the constitution, provision of the constitution or not, Lordship. Lordship to decide the issue, Lordship. Here, Lordship, firstly, my Lord may kindly.
Hmm. What do
My
you
Lord
want
may
to show?
kindly come to Article 16 of the Constitution of India, Lordship.
Kindly read.
Equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to the employment or appointment in any office under the state. 2. No citizen shall on ground only of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminate against in respect of any employment or office under the state lordship. Here,
Mr.
Lordship,
Gogoi,
Lordship, here,
just one thing we are asking.
Lordship.
Have you ever seen
Lordship.
the faculty members of St. Stephen's College, New Delhi?
Lordship,
Have you ever seen in the website?
Lordship, Assamese, Lordship, 30% Assamese are there.
Not the students, faculty
No,
members.
Faculty members, I have seen even faculty members, even Stephen.
Who is the head of the Department of Physics?
Physics, Lordship, today I cannot
Find
say.
out.
Otherwise, Lordship, I know.
Find out.
I know, Lordship.
You know.
I know.
Right.
I know, Lordship.
Now,
Even Lordship.
have you seen the faculty members of Christ College, St. Joseph's College
Lordship,
at Bangalore?
I have seen Lordship, most of the teachers belongs from the Assam, Lordship.
They are teaching subject of English.
Lordship.
They are teaching subject of Sanskrit. They are
Lordship.
teaching subject of
Lordship.
some biology,
Lordship.
something special
Lordship.
in the biology.
Lordship.
So how come, are they resident from that particular
Lordship,
state?
so I am Lordship relying Lordship 16 to Lordship.
Then how come the
16
state government of Assam can pass such
No,
order?
Lordship. So I am just placing Lordship. I am just placing Lordship 16 to is a specific.
That
word.
itself shows how the mindset is.
Lordship. 16 to itself says.
It's
Lordship.
not a hill state that where there is a reservation for grade 4 or grade 3.
Even Lordship, as per the latest apex court judgment, Lordship, till step whether 100% reservation is also not permissible.
Absolutely not.
Not
We are
permissible.
in the state of this state of Nagaland, state of Mizoram, or state of Arunachal Pradesh. There is no. I mean, any outsider can apply for the judicial post.
They
Of
cannot.
course, they must know the local language.
Lordship.
That is the thing.
Lordship.
Even in Assam, forget. That's why I'm saying in the hill
Lordship.
states,
Lordship.
we are conducting the examinations.
Lordship.
We know there is no 100% reservation. So
It's a Lordship violation of the
no,
provisions. of
how
the-
come government can thought about it? How come that came into their mind?
The reasons behind this Lordship, they have Lordship wants to take preference, give preference to the local candidate Lordship for solve the unemployment problem. The main reason is that Lordship. But Lordship, that reason should be some justifiable.
Reservation for a post
Lordship,
is possible when it is, you don't need
Lordship,
an unskilled person.
Lordship,
This is a post where you must have the highest academic qualifications,
Lordship.
right?
Lordship.
As it is not reserved for
Lordship.
any other candidate of that category. Now, when you are asking for the best of the best academic
Lordship.
people there in the job,
Lordship.
so that the students are benefited, can you reserve it to that kind of category?
We cannot lose. The forefathers of the
But
constitution.
that is a
That's
submission of Mr. Gogoi. That is not submission of the government in the higher
Yes, sir.
education department.
The main purpose behind.
Will
the
your
law-
submission make this notification
Make this
invalid?
Lordship. As per the lordship, the provision of the constitution lordship, we cannot lose. As per the apex court judgment also, I am placing all this lordship. But lordship, the main
But what is
reason,
the stand of the government?
main reason behind this, is that lordship, main reason behind this to curb the unemployment problem lordship, the government has issued that lordship. To give the benefits to the local lordship. That is the main reason lordship. And that reason is also lordship, one of the judgment of the constitutional bench, I will place lordship. Although it is not in respect of the employment laws, it is in respect of the admission. That was also decided by the constitutional bench, the honorable apex court, that the state has the power lordship. But in respect of Article 16 lordship, I have searched my friend also lordship. We have not find a single
That's
judgment
not
lordship
fair.
regarding
That's not very fair.
lordship. The main reasons lordship is I am indicated lordship due to the unemployment problem lordship, the state has lordship.
In Guwahati University, there was a very respectable person in the Department of Economics.
Lordship.
You know. And that person who is from the South India.
Even my research is also lordship from South India, is Dr. K.
So you are from the Guwahati University, you know.
Dr. K. Krishna Rao lordship, he is the one of the best economists of the world. at
And
that time, lordship.
very surprisingly, you know, the entire family settled at Assam.
Lordship. Madam is also in the Department of English lordship.
So what the Guwahati University will restrain.
Lordship. Regarding that point, I have lordship, just I am placing lordship, the judgment of the constitutional bench and even a judgment.
See,
also
it is neither in the office memorandum
Lordship.
nor in the advertisement.
Lordship.
How come the question of rejection will be there?
Lordship. That cannot be lordship. If we do so, lordship, the very purpose of the constitution will be failed, lordship.
Now, the Act and the rule says the appointment order has to be given by the Director of Higher Education.
Lordship.
Act is silent, rule is also silent.
Lordship.
That the director is required to forward it to the government for approval.
Lordship.
Then why the director forwarded matter to the government?
Lordship, here, lordship, the issue is that lordship, that particular decision was taken in the government level regarding.
No,
that,
only because this has happened
Lordship.
because director forwarded a matter
Lordship.
finding that the candidate is from a different, the candidate selected is from a different state.
Lordship, in the application form, there is a lordship, there was a one clause lordship.
Hmm.
In application form, lordship, there is a one clause regarding lordship residency.
Where is that?
Residency, here they have not annexed lordship.
See the advertisement.
Lordship.
Come to page number 36.
Lordship. Lordship, advertisement clearly indicates that candidate must be a Indian citizen having lordship proficiency of local language.
So
We cannot lordship.
there is nothing that he should be a resident of
Lordship.
Borak Valley
Lordship.
or Upper Assam or
Lordship.
Lower Assam.
Lordship.
So that will also amount to violation of the provisions of Article 16 of the Constitution.
Lordship. So, lordship, I am just placing one judgment regarding admission part lordship and other lordship I am relying lordship.
That indicates the the
Lordship.
poor mindset of not even poor.
Lordship.
It given the worst mindset of particular.
Lordship.
Not fair. Yes. What are the decisions you have taken?
Lordships. This in respect of lordship admission lordship.
Give us the citations.
Admission lordship. But lordship, it's not related to the Article 16 of the Constitution. Just I point out lordship. Here constitutional judgment lordship, I am relying paragraph 5, 6, 7, 8, 10, and 11 lordship.
There are
Para lordship 5, 6, 7, 8, 10, and 11 lordship.
5, 6, 7, 10 and 11.
11. And Lordship, dissent judgment is authored by my Lord Justice Jagannath Das, Lordship. And now the law, the dissent judgment is all in the field, Lordship. In other things, Lordship. And regarding that particular issue, Lordship, one matter is also pending before the Honorable Apex Court, which come from the state of Haryana, Lordship, regarding admission, Lordship. This matter is pending before the constitutional bench, which was constituted recently, Lordship. That issue was already settled in, Lordship, 1955 regarding admission part, Lordship. And that is again came before the Honorable Apex Court, and it is in pending, Lordship, from state of Haryana, Lordship. Here the main issue is that, Lordship, paragraph 5, Lordship.
Must be a domicile resident.
Lordship, here the regarding admission, Lordship.
Hmm.
Admission part, Lordship, they have,
See, that background of admission is this:
Lordship,
person residing in the locality or in the area,
Lordship,
right, must have the preference.
Lordship.
Now, that is also a case, if you go and ask the school authorities for admission of your ward, you will see your locality, they will tell you.
Lordship.
So anybody who is residing near St. Mary's are
Lordship.
getting seats in St. Mary's.
Lordship, within
But
the
if they are
5
staying in
kilometers
Nunmati
radius,
area or Bunda area, they are not getting seats in
I
St.
also
Mary's.
get benefit from Maligaon St. Mary's, Lordship.
So like that, even if you go to give
Equal
your
resident, Lordship.
admission in Don Bosco or in other schools,
Lordship.
of course, it is not in the other vernacular schools,
Lordship.
but it is in these areas, they have followed that only.
Lordship. That is in that particular matter can be only regarding the, Lordship, the admission purpose. So I am reiterated, Lordship, we have tried, Lordship, but we are not able to find out, Lordship. Now, Lordship, the judgment which I am placing in favor of the petition.
There cannot be any discrimination.
This
That's
is a
right.
recent judgment
With
of
regard to
the,
the employment.
this is a recent judgment of the Honorable Supreme Court Constitutional Bench judgment, Lordship. Paragraph, I am here relying, Lordship, paragraph 68,
Just a
69.
minute, just a minute.
Lordship, Lordship.
You should have given us the citation, why the entire bunch.
Lordship, two,
Nowadays, less paper.
paperless. But Lordship,
Should be,
we are thinking that it will be helpful for the court. Lordship.
Thank you.
Lordship.
Which are the relevant paras you are
11
relying?
paragraph 68, 69, Lordship.
Hmm.
And paragraph 152 to 158, Lordship. Lordship, on the basis of that particular judgment of the Constitutional Bench, Lordship, one judgment was passed by the Honorable Division Bench of the Apex Court recently, Lordship.
Hmm.
And that particular judgment is authored by my Lord Justice M.R. Shah, Lordship, who is also a part of that particular Constitutional Bench, Lordship.
Okay.
এইটো আপুনি বিচাৰিব লাগে বহক বহক মই কৈ আছো বহক My lord, may in that particular constitutional judgment, my lord, may kindly come to page 524, my lord,
Just
524.
what do you want to show?
524, lordship, 166.3, lordship. The questions which was framed by the honorable court is answered, lordship, here. 166.3, lordship. My lord, may kindly note the paragraph 159, 160, 61, 62 up to 64 also, lordship. That part was discussed by
That
the
full bench judgment,
lordship, in the constitutional bench judgment, lordship.
constitution. bench.
Constitutional bench judgment. lordship. Lordship, the question was framed by the honorable apex court was that, lordship, whether the notification merely contemplates a classification under article 16.1 and not reservation under article 16.4, lordship. That was answered by the honorable constitutional bench, lordship. That paragraph, lordship,
Okay, will not give go to that.
lordship, even lordship, the division bench judgment, lordship, which was on relied upon the constitutional bench judgment, was paragraph 17 onwards, lordship. Paragraph 17 onwards.
No, they have discussed all the issues.
Lordship,
Then they came from that one,
lordship.
because that is a case of 100% reservation
100%
for the
reservation.
reserved class of people in the
Lordship.
state of Jharkhand.
Lordship, Jharkhand, they have proceed the
And that was
particular,
set aside by the High Court,
Lordship,
as the
lordship.
language single judge as well by the division bench. That was under challenge.
lordship, they have the reserve under 13 schedule area in the Jharkhand, lordship. So honorable apex court says that it's a violation of article 16, lordship.
Of course, there is a whole judgment of the Honorable Apex Court.
Lordship.
In many of the cases, our High Court in a division bench earlier days also, of course, cited that
Lordship,
there cannot be any such rule
lordship,
violating the provisions of fundamental rights. Okay. Just pass on the record. Heard Mr. J. Amit, counsel appearing for the petitioner, and Mr. K. Gogoi, along with Mr. S. Das, learned standing counsels for the higher education, responding numbers 103. Anyone appearing for the college? No.
College lordship.
Kachar College, Silsar, District Kachar. Is a provincialized college of the state affiliated to the Assam University, Silsar. Principal of the college on 6/06/11/2020 issued an advertisement, white advertisement number ADVT.2020/257, for various posts of assistant professors, including the post of assistant professor of subject Bengali under unreserved, one post of assistant professor of subject Bengali under unreserved category. Notifying that the same has been issued in terms of the notification number AHE.28/2020/4, dated 04/02/2020, of the state government in the higher education department, as well as letter number DHE/CE/MISC /12/2020/4, dated 06/02/2020, of the Director of Higher Education, Assam. Post of inviting applications for the post of officer for direct recruitment in the said college. Right. Clause C of the said advertisement dated 06/11/2020 specified the eligibility criteria and clause C dot 3 dot specified that the candidates must be Indian citizens having proficiency in local language. The eligibility criteria specified in clause C of the said advertisement dated such and such was in terms of the office memorandum of the state government, the higher education department under number AHC.407 public 2017 public 44 dated 08/11/2018. Petitioner is a resident of district Purbo Medinipur, West Bengal. Pursuant to the said advertisement dated 06/11/2020 of Kachar College noted above. She having the requisite eligibility applied for the said post and was called for interview by the college authority along with other candidates for the post of assistant professor of Bengali. The altogether 25 candidates were found eligible for the post of such and such, pursuant to the such and such, for which selection was held on 10/02/2021 from 11 a.m. onwards in the campus of in the premises of Kachar College. Silchar. The The concerned selection committee of the Kachar College recommended the name of the petitioner for a post of assistant professor of Bengali as advertised on 06/11/2020, and the governing body of the said college, along with the records of said selection, forwarded the name of the petitioner to the Director of Higher Education Assam for issuance of necessary approval and issuance of order of appointment. Taragote likha. Assam, the Assam College employees within bracket provincialization bracket close rules 2010. Frame under the provisions of subsection 12 within bracket 1 of the Assam College Employees Provincialization Act 2005. Comma, having statutory force, came into effect from 22/11/2010. Rule 5 of say 2010 rules relates to method of recruitment. Rule 5 within bracket 2 of say 2010 rules stipulates that for the post of lecturer, librarian, appointments shall be made by direct recruitment with prescribed qualifications through open advertisement in 2 leading dailies, at least in 2 consecutive issues. Rule 5 within bracket 6 of say 2010 rules provides that the placement of lecturers of librarians in seven 5/7 provides that in all cases the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. Rule 7 of say 2010 rules relates to direct recruitment. Which provides that Rule 7. Following the same point, after such selection by the college selection committee, found the petitioner to be the suitable candidate for appointment to the post of assistant professor of Bengali in the said college as advertisement on such and such 6/11/2020. And accordingly, the governing body of Kachar College, Silchar, Kachar, forwarded the name of the petitioner to the director of higher education. I got to comment. However, the director of higher education Assam informed the college authority that all the colleges, provincialized colleges of the state, that the state government in the higher education, while letter number AHE.429/2021/part/3, only part one, all PT, dated 01/02/2022, intimated that The government of Assam in the higher education department regretted to consider the proposal for appointment of assistant professor in provincialized colleges who are from outside the state. Since the petitioner is from the state of West Bengal, comma, though her name was recommended for the post of assistant professor of Bengali in Kachar College structure in terms of her selection, pursuant to the advertisement dated 06/11/2020. The Director of Higher Education Assam did not give its approval for appointment of the practitioner in the said advertised post in Kachar College, Silsar Kachar. Because of the said letter of the state government higher education dated 01/02/2022. Being aggrieved, petitioner has preferred this writ petition, filed this writ petition on 18/02/2022. Well, this is praying amongst others for setting aside and cause the letter of said letter of the state government higher education dated 01/02/2022. The communication of the Director of Higher Education Assam dated 20/02/2022. Noted above. And for a direction to the state respondent authorities will to appoint her as an assistant professor in the post of assistant professor of Bengali in Kachar College, Silsar Kachar, against the unreserved post advertised on 06/11/2020 on the basis of her selection. The court on 23/02/2022, while issuing notice to the respondents, specifically directed the respondent authorities to file an affidavit stating in precise term as to under what circumstance and under which decision of the government of Assam it found the petitioner ineligible to be appointed pursuant to the said advertisement dated 06/11/2020 issued by the authorities of Kachar College, Silsar Kachar. However, the respondent authorities did not file any affidavit in the matter. Pursuant to the order of the court, the respondent authorities in the higher education department of the state placed the relevant file in original in which the state government in the higher education department issued the letter number such and such dated 01/02/2022. 2022. There a different file, Mr. Gogoi.
Lordships,
There appears to be a different file.
we have received only that file. If Lordship directed the police that particular file, I can also.
So the record is very clear
Lordship,
that the Director of Higher Education Assam
Lordship,
forwarded a detailed list of 137 such assistant professors. different provincialized colleges of the state for approval to the government. And departmental minister, honorable chief minister, all decided that the appointment orders will be distributed accordingly. So that contain 137 post of assistant professors from the director of higher education. Then 16 grade 3 from the higher education. 495 teachers of provincialized schools. Then 88 schools. 65 tutors. Then 7 post of grade 3, the higher education, compassionate ground. 1 grade 4, grade 3 in the technical education department. And then all they decided that they will give altogether 721 appointment orders will be distributed ceremoniously in a particular date. So that was agreed by the honorable departmental minister as well as the chief minister. Now, during that process of approval to be given by the state government in the higher education department, they found 4 of such teachers, 4 of such selected candidates
Outside the state.
in different colleges. On selection found to be from
State of
outside
Bengal.
the state. And those 4 persons' names were forwarded by the higher education, director of higher education. At that stage, there was nothing. And there are some 3 teachers, 3 selected candidates. Those who are also from the outside the state. So altogether, 7 such candidates were found from outside the state. So with regard to the first 4, necessary approval of the higher education was there. That includes the client of the Mr. Ahmed. We are not involved with the next 3. In that particular approval of the director of higher education, departmental minister said, we may not allow. There is no reason. The note sheet shows that since the departmental minister has given that note, they have come out with that letter of 1st of February 2020.
There is the reason.
Is it possible?
Yes.
Record listening. From the record, it is seen that the director of higher education Assam submitted its proposal before the government of Assam in the higher education department, containing a list of 137 numbers of selected candidate for the post of assistant professor in different provincialized colleges of the state, selected and approved by the respective concerned authorities of the provincialized colleges. And on preparation of appointment orders names of 4 such candidates out of which 137 approved candidates. It was detected that those candidates, 4 candidates are out from outside the state of Assam. And accordingly, the Director of Higher Education Assam, by its communication number DHE oblique CE oblique MISC oblique 49 oblique 2021 oblique 65 dated 26/11/2021, wrote to the government in the Higher Education Department for its approval. In which the concerned departmental minister on 27/11/2021 observed not to allow any such appointment. Pursuant to the said observation, the said observation dated 27/11. The state government, the Higher Education Department, on Zero 01/02/2022 issued the communication number AHE.429/2001 part 2021/PT/3 to the Director of Higher Education Assam, expressing its regret to consider the proposal for appointment of assistant professor in provincialized colleges who are from outside the state, directing the DHE Assam to take action accordingly. On the basis of the same, the Director of Higher Education Assam on 10/2/2022 informed all the principals of the provincialized colleges of the state about the decision of the government in this Higher Education Department about such regret of the state government, the higher education, regarding appointment of assistant professor in provincialized colleges of the state who are from outside of the state. It is to be noted herein that since the 2010 rules noted above do not provide for any such guidelines for selection of assistant professor in provincialized colleges of the state. As such, the state government in the higher education wide number AHE.407/2017/44 dated 08/11/2018 issued an office memorandum in that regard. Thereafter, the state government, the Higher Education Department by number AHE.407/2017/54 dated 25/11/2020 issued another office memorandum stipulating the guidelines for selection of assistant professors of librarians in provincialized colleges and government model colleges of the state. And in both the office memorandums dated 08/11/2018 and 25/11/2020, one of the criteria was that the candidate must have proficiency in local language. Amongst other eligibility criteria. However, both the office memorandums did not have any such clause that only the candidates from the state of Assam residing in this resident public domicile of Assam is eligible to apply for the post of assistant professor in provincialized colleges of the state. From the records we have, it is also seen that the Director of Higher Education Assam gave approval for appointment of the petitioner, and even the state government in higher education department also conveyed its administrative approval by letter number AHE.429 /2021/23 dated 18/11/2021. But when the Directorate of Higher Education, while preparing the appointment orders, found that petitioner belongs to the state of West Bengal, and accordingly, and as such, accordingly, on 26/11/2021, it wrote back to the government in the higher education department seeking necessary instruction regarding issue of appointment of such selected candidates where there is already an administrative approval from the state government higher education for issuance of appointment orders who are selected from outside the state of Assam. Article 16, not query. Article 16 of the Constitution of India. Mr. K. Gogoi, Standing Council, Higher Education. Fairly submitted that there cannot be any such restrictions with regard to the public employment, violating the provisions of Article 16 of the Constitution of India. For proper adjudication of the matter, Mr. Gogoi have also placed the decisions of the Honorable Apex Court, the constitution-based decision of the Honorable Apex Court in the case of Sebrolu Lila, Chebrolu Lila, LWLA, Prasad Rao and others versus State of Andhra Pradesh and others, reported in 2021 11 SCC 401, as well as the case of Satyajit Kumar and others versus State of Jharkhand and others, reported in 2022 11 scale SCLE all capital 640, equivalent to 2022 bracket of equivalent 8 JT judgment to data 50.
And also SCC online also, Lordship, 2022 SCC online SC 954 Lordship.
Kindly repeat.
2022 SCC online SC 954 Lordship.
Equivalent citation deliver. Mr. Gogoi has also placed a decision. Constitution bench decision of the Honorable Apex Court in the case of D.P. Joshi versus State of Madhya Bharat and another reported in AIR 1955 SC 334 that relates to domicile of like resident and with regard to admission in a particular course in the state of Madhya Bharat, now Madhya Pradesh. Considering the interest of the matter, after hearing the counsel for the parties, it is found that decision of the state government in higher education department communicated by 1/10/2025 1/10/2022 orders is in violation of the provisions of the Article 16 of the Constitution of India. And which is not tenable in law. Accordingly, said decision of the state government higher education department communicated by such and such being illegal is hereby set aside and passed. Consequently, the communication dated 10/2/2022 of the Director of Higher Education Assam informing all the principals of the provincialized, the principals of all provincialized colleges of the state about the said decision of the state government higher education dated such and such. Also not sustainable law is thereby set aside at first. Since the Director of Higher Education had already granted its approval regarding selection to the selection of the petitioner to the post of assistant professor in Bengali as advertised under unreserved category, as advertised in the Kachar College, Kachar College, Silsar Kachar, as advertised on 06/11/2020, which has also obtained got the administrative approval of the state government in the higher education department. Therefore, the Director of Higher Education is directed to issue appointment order to the petitioner as assistant professor in the subject of Bengali, Kachar College, Silsar, District Kachar, person to, in terms of the advertisement such and such, forfeit. Let the records be here for some time. After completion of the order, we will take it back.
Second one is MLA subject mathematics.
Let it be typed out first, then we'll see that. Mr. Gogoi, in case of higher education, they are not taking any advices from you, other councils or of their own, they are doing it.
They are not. Always.
Item number 3. Three,
Registry shall place this matter on Friday, date to Friday. Reflecting the name of Standing Council UGC, Mr. A. Somwa. For the response number 12, along with Standing Council. Higher education. You are also appearing for Pandit Dindayal Upadhyaya, all the colleges. Fine, we will do. Friday on 24th. Mr. Soma, your name hasn't been reflected, though you have appeared. It's the matter on Friday,
Coming Friday,
this Friday.
can be little later.
Why?
Take instruction on this point that prior to 2009 regulation, if the MPhil degrees were taken under ODL mode, it will be valid or not. To my information, it is valid. Only thing that whether the examinations were given going into that university or
ODL mode person appearing from state of Assam in the course given by some Tamil Nadu will be valid.
no. The examination has to be in the campus. But nowadays, well, from 2009, 10 July onwards, MPhil and PhD cannot be provided through
This
ODL.
has to be in it, right?
Prior to 2009, it was provided. It will be valid only if they went there to give the examination.
No, only for the examination,
Yes,
not to attend the classes.
no. ODL mode earlier it was allowed. For examination purpose, they have to go there.
It's a wrong submission also. It has settled law 2005, Professor Espal case lawsuit. And Kumansal University's case, Honorable Apex Court says that lawsuit where UGC was also a party. Honorable Apex Court says within the territorial jurisdiction, they have the center.
Definitely.
That's
That's
what I'm saying.
The center should be within the territorial jurisdiction. One university operating in Madras lawsuit, they cannot open a center in the Assam lawsuit.
That's what I'm saying. They have to, how this is wrong information?
You says that they can open any center in any
How,
state.
when I said that?
They said that
They could take admission, suppose a university situated, anomalized university situated in Tamil Nadu. The person from Guwahati can take admission for a course, but he has to go there for examination. Examination center, off campus, this cannot be here.
Off campus center and examination center in a particular territorial jurisdiction.
Yes, that is what my submission is.
Likha. We'll give you some time, more time. The respondent UGC units shall apprise the court
Exam to ব্যৱহাৰ কৰি গৈছে আপুনি। বাকী কোৱা নাই না।
as to whether
Center পঢ়িব ক'ত? পঢ়িব
prior to,
Center line.
what is the specific date?
And
That 2009, the cutoff date.
10 July 2009.
10 July 2009 lawsuit in respect of lawsuit the course of the distance mode lawsuit regarding PhD and MPhil lawsuit.
Likha.
2009 is a lawsuit regulations
As to whether-
regarding lawsuit the obtaining of the PhD degree and MPhil degree lawsuit. Not lawsuit
The
in case of
degree of MPhil and PhD obtained by the candidates from different UGC recognized universities in a distant mode is considered to be valid or not? And if so, for which MPhil degree or PhD degree or for both the degrees, and up to which date? Further, the UGC shall also apprise as to whether any such MPhil PhD degrees obtained by the candidates from such UGC recognized universities in the off-campus mode till such specific date is valid or not. We give the border things. You give us up to which date the MPhil or PhD degree obtained by the candidates through distance mode is valid. Number one, up to which date, whether only for MPhil or for PhD or for both the degrees from such universities duly recognized by the UGC. Number one. Second is whether such off-campus
Off-campus aspect. is
PhD,
settled.
MPhil obtained by the candidates valid or not, in distant mode
That is
valid
settled,
or
we'll say.
is up to
Will inform.
both the things.
Right.
If you are agreeing that yes, in the distance mode, it was allowed up to 10th of July 2009. And in that period, also the off-campus was allowed, or that in that period also the off-campus was not allowed.
Off-campus was not allowed throughout the.
Tell us, in another case
Off-campus
also,
has never been allowed in any case of.
in
any
another
time.
case, we have also directed to UGC file a affidavit where recently from a college, Barak Valley College, I forgot the name, where the candidate obtained its PhD degree from Mr. Das. You are in that case, I think so. SK Das. That South Indian University, Pondicherry or something. Are you there in that case? Probably Pondicherry University's case.
From Sam Higginbotham University.
No, not that
is
one.
Industry does.
Industry does and.
That was decided.
That has been decided and retaping was preferred, retaping was also discussed.
No, Mr. Das, just wait for a few minutes. That one in probably Pondicherry University.
Lordship, Pondicherry University regarding Lordship, Sunita Karipak Lordship.
Sunita Karipa.
Sunita Karipak Lordship has directed the file affidavit to the UGC as well as Pondicherry University. Lordship.
That's right.
Lordship.
I forgot the party name.
Sunita Karipak Lordship.
Yes, yes, I remember.
Last
I
week,
was
last
on
week,
leg
it was-
in the-
last week. it was-
That you have to file in that
Man,
case.
we'll do that.
When do you want to tell us?
Well, at any date in second week of March, Milord, because first week Holi, I will not be at the station.
On 14th of March.
14th, well, that High Court matter is fixed. 15th, Milord,
Okay, on 16th.
16th. Well, let me record my presence today,
Correct.
and name has to be reflected.
Okay, we'll look into it. Mr. Das,
May,
where
may I pray for a copy of this also?
yesterday we're looking for you, one of the cases where the his lordship as well as Justice Bopanna along with Justice Goswami as well as lordship here passed an order with regard to NCT, remember? Is it the Higginbotham's Institute where it passed?
Because Lamba, because Lamba and Somit was not both.
Justice Lamba? I don't think so.
That
There
is
was,
what- that-
there
that
was
was what
another
the-
decision by Justice Bopanna who had specified that NCT came into force with this particular date. And no further consideration to be made. There is a specific, because you remember that case where you appeared along with Madam Saikia and Saikia.
That
There
is,
the division bench judgment was placed. Justice Bopanna and that Justice Lamba's decision along with just Brother Justice Saikia came later.
that decision was,
Either Justice Goswami or Brother Justice Bujur Bujur.
that is Lordship read April 55. That is pertaining to Lordship,
Can you give us the number?
that is Lordship pertaining to again Lordship that Sam again written Lordship.
That is B.Ed degree, not with the another thing. The matter cropped up from the Borak Valley, some Silsar, I think so, regarding appointment of,
Read April 55 of 2019.
this is,
Ajay Lomba and Sumitra Soikia.
no, that is later. Prior to this, there was a judgment of Justice Bopanna. Very clearly, it was placed. Even yesterday, we inquired Mr. Alam, he couldn't say, but there was a specific judgment. Justice
In that
Bopanna,
case, Justice Bopanna and Arup Kumar Goswami, Lordship, in that case, Lordship, an interlocutory application was also filed. The interlocutory application was also dismissed.
remember,
Yes.
on that decision we are looking for.
That is the interlocutory application, 884 of 2019.
That order was passed in the interlocutory application. Do you have that number?
Yes, Lordship. But that is again pertaining to Lordship, postgraduate degree, not pertaining to the B.Ed degree. Lordship.
I think there is an NCT.
April 354 of 2008.
Oh, second, that's Lordship.
Bopanna and Ekebusa.
354.
354 of 2018.
Justice Bopanna and Justice Goswami. That's right.
Order dated 29 April 2019.
29/04/2019.
Very specifically said that NCT Act came into force.
That's right. That's I remember that. That's why I forgot this one, but remember the contents.
354, no?
Item 7, let's see if it is annexed.
Is the next. I couldn't see yesterday. I did not see. Well, just glancing it. Hey, duta kintu uliyai ko. Soma hele uliyai ko. Duta uliyai.
Second, that's Lordship, no?
Okay. We'll have. Thank you, Mr.
Some supplementary list, item number 8.
Get hold of Mr. Majumdar. Ask Mr. Majumdar to be here.
Lordship, reason next is put number 3, Lordship.
Mr. Sharma, for something, we'll get the other matter. Because his presence will be required, even if we hear you. Where is Alam? Kali meta to put. Anand. Kali it is a question.
Yesterday's matter was listed before the court number 3 matter in supplementary line.
Item number 4 to 7.
Mr. Khatanian, what was that college? Which college of education it was there in? Is it Silchar or what?
Dr. Shashi Bhushan Institute of School
Hailakandi,
Education.
madam. In fact, your lordship's order was challenged before the division bench in WA number 197 of 2020. And that was, as on today, not interfered.
That is with regard to Shashi Bhushan.
No, this is regard to Karimganj Law College. madam.
Uh-huh.
That is Karimganj Law College, Vivekananda, my lord.
Okay.
Division bench, while granting the, my lord, issuing the notice, has stated that the pension of the lead appellant should be settled, excluding the benefit given for the B.Ed degree. And the case of Shirajul Ambia is, my lord, went to Supreme Court also, my lord, and from there it has come back again before this honorable court and pending in the review stage. And judgment has not been interfered.
That is Shashi Bhushan, right, Mr. Khatanian?
Yes.
Some particular matter it was there.
Shashi Bhushan, my lord, your lordship will find at page number, item number 5, my lord. Vision Nath.
Yes, who is appearing for the item 4? Yes,
Your Lordship, my senior is having some personal difficulties, so let the matter come up a day after tomorrow.
no. Nothing like that. It was fixed today. It's aware. Who is appearing for the writ petitioner in this matter? This IA is by,
Actually, my lord, it was earlier with me, but file has been taken from me and
okay. Now, what about item number 5? Who is appearing?
I am,
Okay, we'll start with the 5. Mr. Mazumdar is here? Not yet. She's on the, okay, we'll start with item 5. আজি 21 তাৰিখটো আজি কেনে হ'ল? আজি পৰাহে video হ'ব। প্ৰব্লেমটো কি হৈছে?
in item 5, my lord, NCT has filed the affidavit, my lord, and they have verified.
Okay. Steps not taken on that particular college?
They have appeared, my lord.
Shashi Bhushan College appeared.
And they have appeared. That's taken by me in the year 2017 itself. Eighteen 7/2017.
Just a minute. This 4291 relates to Hailakandi.
Yes.
Sharma. A2 blue file to some. 4291. Four two nine one और blue file to that. Packet नहीं. Packet lawyer. 4291 और blue file to that. Mr. Doctor, Prakash, sir, this there's an order passed earlier on.
Lordship is taking out item number 5.
4, 5.
Lordship may have pressed something.
Just a minute, we'll come back to you. Sharma. এইটো বিষয়ে তাৰমানে activity হৈছেতো, কেছটো হেৰি হৈ আছে। এই কেছটো চাওকচোন। You just see because steps was taken. You took step on 28 and letter was forwarded on 29, registered post by 30th of
Yes.
January 2019. Let us see by this time get the report. Yes, you please argue. See.
My lord, in this case, we have challenged the BEd qualification of the private respondent, my lord.
Hmm.
Because during the period when she procured the BEd degree, my lord, at that point of time, it was not under the NCT.
So initially it was Hailakandi B.Ed College.
Yes,
It was
renamed as
functioning from a rented school,
might be.
in a private rented school. And then
Then they
for
have
the
got-
first time, it applied for the approval of the, or the recognition of the NCT on for the first time it applied. There's a specific date which you could see here is August 12th, 1997. It applied for the first time on August 12th, 1997. Now, one important issue is that respondent number 7 has filed an affidavit here. 2 affidavits are there of the respondent number 7. In the first affidavit, the respondent number 7 annexed some notifications of the UGC and the clarification made by the UGC about the master degree obtained by the petitioner,
Yes.
right? From Sam Higginbottom Institute of Agriculture. Then, of course, the affidavit of the NCT is there. Then the petition respondent number 7 filed an additional affidavit that was filed on 30th of November 2021. Now, from that affidavit, interior page 10 of the respondent number 7. This is a letter from the Assam University on 5/7/1996. Now, it is settled that NCT Act came into force
1st of July
2015,
1995.
sorry, 1995,
17 1995.
17/1995. Now, if you read that affidavit of the respondent number 7, you will see that the Assam University on 5/7/1996, please come to page number 11 of that affidavit, internal page 11. Read 4.
The proposal to start a B.Ed college in the district headquarters of Hailakandi under the name of Hailakandi B.Ed College was considered, and it was unanimously resolved that the permission be accorded to that Hailakandi B.Ed College at Hailakandi for the session 96-97, subject to the fulfillment of conditions as have been laid down by the university.
Good.
This is by the university.
And that is a letter of 5/7/1996. Now please come to the letter of the NCT. That is at page 16. Now kindly read this letter. That is a letter of 29 July 1997 to the Assam University. Kindly read.
I am to draw your kind attention to the fact that according to the provisional contained in section 14 of the NCT Act 1993, every institution offering a course or training in teacher education before the appointed day, that is 17th August 1995, has to apply for recognition to the concerned regional committee of the NCT within a period of 6 months from that date. The provisions of the said act are applicable to all colleges and the departments of education in all the universities offering B.Ed and other teacher education courses. It is mandatory for all teacher training institutions to obtain recognition from the NCT due to lack of information about the procedures. Many of the colleges and departments of education did not apply for recognition within the stipulated time. The procedure and norms and standards for recognition have already been notified in the Gazette of India by the Council. In order to provide a fresh opportunity for non-applying colleges and departments of education in the last date for receipt of the applications by the 4 regional committees of the council has been extended up to 18th August 1997. In accordance with the provisions contained in section 16 of the NCT Act, after the 17th August 1995, no examination body can grant affiliation, provisional or otherwise, to any institution or hold examination, whether provisional or otherwise, for a course or training conducted by an institution, unless the institution concerned has contained recognition permission from the regional committee concerned under the provisions of section 14 or 15 of the Act. Further, in accordance with the provisions contained in section 17 of the Act, qualification in teacher education pursuant to a course or training from institutions which call or neglect to obtain recognition of the permission under the Act shall not be treated as a valid qualification for the purpose of employment under the central government, any state government or university, or in any school, college, or other educational body aided by the central government or any state government. It will thus be seen that while the universities cannot grant affiliation to a college offering B.Ed, etc., courses and cannot hold examinations for a course or training offered by an institution unless the institution concerned has secured recognition from the NCT. The students pursuing courses from such an unrecognized institutions will suffer serious adverse consequences in the matter of securing employment. In view of the position explained above, there is an urgent necessity for all colleges and university departments of education offering B.Ed and other teacher training courses to apply to the concerned regional committee of the NCT for recognition. It is requested that you may please issue necessary instructions to all colleges affiliated to your university and offering teacher training courses as well as to your departments of education to immediately apply for recognition well before the last date, that is 18th August 2027. A copy of this instruction issued by you may please be endorsed to the council.
Okay. Now that is clear that any such B.Ed college without such approval of the NCT and the affiliated university concern also recognizes such degree will not be considered for the purpose of employment, either in the central government or in the state government. Right?
Yes,
That is have NCT have clarified. But here what we have seen that the act came into force of 1st of July 1995,
yes.
and the university has for the first time granted approval to this particular Hailakandi B.Ed college, which is now later on named as Sasibhushan College, right? Sasibhushan College of something. Sasibhushan College, it was name or change something.
Hailakandi College.
No, Hailakandi College has become Sasibhushan College.
Sure.
So it was the university, Assam University on 5/7/1996. Though the act came into prior to 1 year of that, this recognition, first recognition given by the NCT, by the Assam University. Now this is one letter. Thereafter, another letter was issued by the NCT. Please come to page number 20. Internal page 20. Candidate. Recognition of permitted.
Recognition of permitted B.Ed colleges in Assam.
Hmm.
With reference to your letter on the subjects I mentioned above, I am to say that Difu B.Ed College and Hailakandi B.Ed College have not applied to this office for recognition. Since we do not have the complete address of those two colleges, may I request you to advise them to submit their applications for recognition complete in all respect by 18/8/1997, which is the last date of receipt of these applications in this office. Information which you have been given regarding permitted colleges under your university is very useful for consideration of these applications as requested in this office letter number such and such dated 4/8/1997. We require some more information in this regard. Please furnish the same and let us know if the students appearing from the permitted colleges as treated are treated as colleges
Collegiate candidates.
collegiate candidates or non-collegiate candidates. In terms of section 17(4) of the NCT Act, qualification pursuant to a course or training in a teacher education institution not recognized by NCT is not valid for purposes of employment. Hence, colleges who have admitted students for the said course without NCT recognition have done so at their own risk and responsibility.
So this is with regard to the Hailakandi B.Ed College, renamed as Sasibhushan.
Yes.
Now come to page number 21. This is for the first time they have applied when on 12/8/1997. Yes, kindly read.
Your letter says, with reference to the subject cited above, I have the honor to furnish here with an application pro forma in triplicate with a
Bank
bank draft number such and such, only along with a blueprint paper of the proposed college building and undertaking on non-judicial stamp paper, xerox copy of land documents, list of staff members, and list of admission of trainees, no objection certificate of headmasters, principals, etc. of bank balances are enclosed here. This is for information. This is the application. As per your lordship's earlier judgment, my lord, they are not covered.
That's why, but that is also upheld by the division bench, or it was returned back.
It is earlier judgment has not been interfered by the division bench as of now. It is pending in the WA number 197 of 2020. The two dates are there as per this act and as per that letter. And both the issues are separately pending before the division bench instead.
Now, please come to the affidavit of the NCT. It was filed on 14th of March 2019.
Yes, paragraph 3, my lord.
Kindly read.
That your humble deponent begs to state that in considering controversy raised in the writ petition, deponent begs to state that the B.Ed degree obtained prior to 15/6/2001 is not a valid degree. The Eastern Regional Committee NCT grants recognition to Dr. Shashi Bhushan Institute of Education, Lakhirband, Boalipar, Bazar, Hailakandi, Assam by an order number dated 15/6/2001. The respondent number 7, Srimati Gitosri Das, obtained B.Ed degree in the year 1997 and certificate issued on by the university on 4/4/2000, which is prior to recognition of the NCT. As such, B.Ed degree is not a valid degree.
Mr. Das,
This affidavit was filed when this issue, this additional affidavit I have brought on record lordship. Subsequently, the issue has developed. Now, lordship, I want to place one order, lordship. He was my classmate in 1996-97 batch, and we passed in the same year from the same college. Because the NCT affidavit did not cover the case of where the institution had applied before 18/8/19 before the cutoff date.
That is the
So it
subsequent.
was at the initial stage the NCT had filed the affidavit. Now, lordship, the issue has developed, lordship. Now, if the institution has applied before the cutoff date, your lordship has seen that letter, lordship. Now, this Mofiruddin, he is the same batch from 1995-96 batch, and we passed in the same year, 1997. In this case, lordship, the matter was considered by this honorable court, and finally it was remanded back before the director.
As of now, my lord, Mofiruddin has not been given the.
Before the additional secretary to the government of Assam, lordship.
He has not been given. He has not been given as of now.
Let me submit, Mr. Pragasta. Then the matter was remanded back to the additional secretary to the government of Assam in the secondary education department for his determination firstly whether Dr. Shashi Bhushan Institute of Education had made its application prior to 18/8/1997, and secondly whether the state institute was in existence as on 17/8/1995 when the NCT Act came into force, and accordingly passed a region order dear lords. That you also will find at page 5 of the judgment, lords, paragraph 15. Now finally, lordship, this case was considered by the department, lordship, and I placed it, lordship. It was also the judicial department view was also taken, and the person, lordship, he was appointed as a regular principal. I am in the same footing. I have been selected as a regular principal. Now, because of the dispute litigation, lordship, I have not been appointed till date. Now, recently, I have been appointed as in-charge principal. I am a regularly selected principal, lordship.
Find the
Mr.
issue.
Das, kindly tell us one thing.
Yes.
Whether the NCT,
Yes.
which is the apex body to consider such recognition of B.Ed degree,
Yes.
Section 74 gave the date is that application is to be made by August.
Right.
Now, during that period,
Yes.
in the case in hand, it is 1st July 1995, the act came into force.
Yes.
And it is the Assam University on 5th of July 1996 for the first time,
Yes.
gave recognition to the Hailakandi B.Ed College. It applied in August 1997, 12th August probably. Now, who will decide that the students who have passed out from this particular institute during till the time of filing of such application,
Yes.
let us assume, or till such recognition is given by the NCT, whether it will state will decide or the NCT will, because NCT Act came into force from 1st of July 1995. So any recognition to be given by, it has to be the NCT only and nobody else. Now, between from 1st of July to 1995 till the date of giving the concurrence by the NCT
Yes.
in 2001,
Yes.
That moratorium period.
whether the students who have passed out from this particular institute, their B.Ed degrees is valid or not, whether it will be given by the state or it will be considered by the NCT.
Also, that can very well be considered by the appointing authority also. Whether the
When the NCTE categorically stated
also,
that during this particular period,
also.
any such degree obtained by or on conferred by any such institute will not be valid for any employment, either in the central or in the state. Because that B.Ed degree from 1/7/1995, it is the domain of NCT. Nobody can do anything to that, right? So neither the state nor the central government, unless that particular provisions of the act is amended or something. Now, only the time of application, instead of 6 months, it was extended up to August 1997. Can you show us anything at any point of time the NCT have recognized that students admitted from the date of application till the recognition given by the NCT shall be valid, or till such application filed by the concerned B.Ed institute for their recognition by the NCT is considered to be valid? Because they have specifically stated that any such degree obtained or B.Ed degree obtained by these, conferred by these institutes to any students is not valid for any public employment, either in the state or in the central.
So, but in terms of the judgment, passed by the honorable court also.
No, that is a different issue. That was not brought to the notice of the court. We don't know who was there in the council, but this is a particular, in this particular matter,
Okay.
your client has filed this affidavit, wherein the NCT has categorically, those notifications of the NCT was annexed by in your affidavit, right?
That was.
Where it is very clear that during this period, till such they obtain such recognition from the NCT, any such degree conferred. So
Also, even the appointing authority, because
how come appointing authority? It is the B.Ed degree has to be valid during this particular period.
so this
Period is A to B. During this period, if any such degree is not considered not to be valid for any employment, state, central, everywhere, by the NCT, whether the state can of its own can take a decision.
no, it has already been held that those institutions who had applied before the cutoff date, so those degrees will be valid.
Though-
in terms
During
of
that
the-
period, That
Before,
is the reason we are asking you. From the date of application
before the
or-
cutoff, before the cutoff date. Lordship.
before the cutoff date. That's right. Before the cutoff date.
In the instant.
You have applied, this particular institute has applied for their recognition on 12th of August 1997. So if any students were appointed or admitted in this particular institution from 12 August 1997, or any degree conferred in the year 1998, or in the year 1999, or in the year 2000, because it got recognition in the year 2001. So the degree that was during that period, that particular period,
That NCT, 14-1 NCT Act also.
read
And Tripati or also. Lordship, the
just a minute.
Upendranath Tripathi judgment. Lordship. No, subsequent extension from that. Done.
Yes, what is 14.1?
14-1 and Lordship, paragraph 18 and 19 of Lordship Upendranath Tripathi's judgment. Lordship, may I read paragraph 18 and 19? A fair reading and analysis of the scheme of the Act with respect to recognition of the institution imparting course or training in teacher education is an essential prelude to the core questions involved. On a plain reading of the provisions, it is evident that on and from the date of enforcement of the Act, every institution offering or intending to offer the course or training in teacher education was required to make application to the regional committee in such form and manner as may be determined by the regulations as provided in section 14 of the Act. The proviso to section 14.1 states that an institution offering a course or training in teacher education immediately before the appointed date shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period and until disposal of the application by the regional committee. What happens in this case of existing institution makes application seeking recognition within the prescribed time, but no decision is taken by the council within the period of 6 months? Does it mean that the institution can impart training only for a period of 6 months and thereafter close the institution? Section 14.5 states that every institution in respect of which recognition has been refused shall discontinue the course or training in teacher education from the end of the academic session. Next, following the date of receipt of the order refusing recognition pass under clause B of subsection 3. Then paragraph 19, Lordship, a plain reading of the provision suggests that all such institutions offering a course or training in teacher education prior to the Act coming into force are entitled to continue such course or training until the application is disposed of or provided such an application has been made within 6 months from the appointed date.
Mr. Das, the difficulty is that where the specific observation prior to the coming of to the act.
In
But
paragraph
here is a case. It got affiliated from Assam University 1 year after the coming into the act. And on that basis, government have considered, without
Yes.
finding the fact that this particular institute got its affiliation from Assam University in the year 1996, July 5th of July 1996. Whereas the act came into force from 1st of July 1996. And Mr. Khataniar, your department is doing like this.
And judicial department's view is also taken.
You can understand.
I'm the same.
When the act is, the judgments of the courts are very clear. Those who have applied and got the affiliation prior to the coming of the act. Here is a case, got the affiliation 1 year after coming into the act. Even then the government have considered. How can it be? How can it? That is the difference we are asking him. That's why the reason we are asking Mr. Prakash to read that one. That it is a recognition of the affiliation of the university is of 5th of July 1996. Then,
But Lordship, paragraph 18 says, Lordship,
hmm,
the provision to section 41 states that an institution offering a course or training in teacher education immediately before the appointed date shall be entitled to continue such course or training for a period of
immediately before appointed date. What is the appointed date?
1/7/1995.
Then here case when it got the affiliation from the university, you are an
Say
excel
December 1995.
December 95 or it is July 1996.
Five, seven.
5/7/1996.
So 57.
1996.
So will it be applicable?
Whether it was established prior to 5/7/1996.
Establishing things are not there. How can a college can be established? You can have a building and everything unless you have an affiliation from a concerned university. When a particular institute is required to be established, it is, if it is an academic institute, then it has to be with the concerned affiliation, not with the having the building. Sarma, 3551 to NP21 already.
Lordship, in this case,
Order dated 9/8/21.
Lordship, there is another litigation between the petitioner and the,
That's a different issue.
in that petition also, I have obtained an interim order also. So that interim order is still operating till this.
It's what? That interim order relates to what?
That interim order relates to, Lordship,
Allowing you to work as in charge.
accordingly, it is directed that in the meantime, the post of principal of Swarna Lakshmi Higher Secondary School, Norsinghpur, Kasar, to which the petitioner had been recommended for appointment, shall not be filled up on regular basis without the leave of this court.
So
So, may I proceed?
shall not be filled up.
And Lordship, the government decision in pursuant to Mofidur's case, Lordship, that judicial department's view was taken. And
Mr. Mozumdar. You appeared in that case of Mafuruddin. Just a minute, just a minute. You have a glance in the affidavit of the respondent. Number 7. Respondent number 7. Affidavit of the respondent number 7. There are 2 affidavits.
Additional affidavit.
In the affidavit, additional affidavit, see page number 10.
My lord.
See the date of the Assam University. On the left side,
Dated 5/7/96.
5/7/1996.
My lord.
Then please turn to page number 11, serial number 4. Kindly read.
The proposal to start a B.Ed college in the district headquarters of Hailakandi under the name of Hailakandi B.Ed College was considered. And it was unanimously resolved that permission to be accorded to start Hailakandi B.Ed College at Hailakandi for the session 96-97, subject to fulfillment of the conditions as have been laid down by the university.
Right. This is 1 year and 4 days later after the act came into force. To start, not the past service as continuous, right? To start.
Yes.
Now you read this order of the court. Very clear. Do you have the order?
Yes, ma'am.
Read para 14. Do you have a copy?
As the order dated 29/7/21 was passed by the Additional Secretary of the Government of Assam in the secondary education by an incorrect appreciation of the law as well as the facts, we remand the matter back to the Additional Secretary for a fresh consideration by taking into account that in the Pranita Sharma judgment, the last date for submission of application has been held to be 18/8/97, and any institute which makes its application prior to the said date, the B.Ed degree obtained from such institution would be a valid B.Ed degree. But at the same time, a determination would also be required whether the institute which has submitted its application prior to 18/8/97 was in existence as on 17/8/95 when the NCT came into force.
Read para 15.
For both the aspect matters since remanded back to the Additional Secretary to the Government of Assam for its determination, firstly, whether Shashi Bhushan Institute of Education had made its application prior to 18/8/97. Secondly, whether the institute was in existence as on 17/8/95 and accordingly pass a recent order thereon.
Now read this decision of the government. 2nd of June. You have a copy? Can take this. Borua did.
Yes,
You
ma'am,
have- Okay.
regarding compliance of court order,
Hmm.
with reference to the subject cited above, I am directed to inform you that Honorable Guwahati High Court in its order dated 9/8/21, the matter regarding appointment, second paragraph matter.
Hmm.
Accordingly, a report was called from Regional Director NCT. Subsequently, Regional Director has submitted a report on 16/11/2021, where ERC NCT has informed that an application for grant of recognition for B.Ed course dated 12/8/97 was submitted by the institution, namely Shashi Bhushan Institute of College or so and so. Matter was also referred to Judicial Department for their legal revision LR. In the instant case, namely Shashi Bhushan Institute of Education has applied to NCT on 12/8/97 and therefore B.Ed degree of Mukhruddin, whether it was in existence has not been considered at all.
So to do whatever is required. The second part, para 15,
Yes.
where is that?
17 and that is what my lord, whether
If it
was
is
in
not there-
existence or not.
Only because of the view of the LR and the judicial department is sufficient. Do whatever you like. Is that the way you do? Is your government functions like that, particularly in education?
Mokhtaruddin was my classmate. He has got
That
all
doesn't
the
matter. If the petitioner is that, petitioner will also not be entitled. It is not that somebody should get it, but whether the valid degree obtained by this petitioner or the respondent is a valid or not, that is the issue. We are not on others.
Same
The
batchmate.
court has no grudge against the petitioner or the
batchmate,
respondent number
same-
7.
Same year of passing, same batchmate, and Lordship. he
That
has
they'll
been
do.
appointed.
And Mr. Mazumdar, pass that order that it was in existence when this act came into force.
Yes.
So it was not in existence.
You know better. Do whatever with this order. We'll pass the order in the second half, and Mr. Mazumdar be there in the second half for that matter, Dibrugarh.
My lord, yes, sir. In fact, my lord, at 2 o'clock, I have been called for court number 1. So my lord, whatever order
No
has been
problem,
passed.
Lordship. We talked, Lordship. He said that he will go for the class and he will attend the library and all. And
Ask
they
someone
will-
to be here.
Yes, my lord. Means my lord, they attend the classes, they attend the library if required. The others, my lord, let them give an undertaking that they would not. What was
Tell
the
us-
first order of lordships, my lord? Because here the issue is with the employees, not the students. They have mishandled employees. We do not want contact with their contact with the employees. May lead to a ruckus. Otherwise, my lord, they file an appeal. We'll dispose of the appeal, giving them all opportunities that they seek for.
Appeal, Lordship, they have to give a notice, Lordship. The notice has not come. In my case, notice. there is
No, no, in no case, you have to tell us what the students want, they tell us, we give them everything.
I must know what is
We
this.
do not-
I
we do
don't
not
know,
start with
because the notice is not there. That's the whole problem, Lordship.
We have to write early, there are interviews. So what will you do? We'll just share Mr. Sharma
No, no.
and get back to you tomorrow.
Yes.
We'll take up this matter tomorrow again. Two 2017. Petitioner challenge the appointment of the respondent number 7 as principal. Challenge the appointment, selection and appointment of respondent number 7 as principal of Swarna Lakshmi Higher Secondary School, Narsingpur in the district of Kachar, a provincialized higher secondary school of district. Alleging that the B.Ed degree obtained by her from Hailakandi B.Ed College renamed as Sosi Bhushan Institute of Dr. Sosi Bhushan Institute of Education, comma, Hailakandi, in the year 1997 is not a valid B.Ed degree. In terms of the provisions of the NCT Act 1995. During the deliberation of the matter, Mr. S.K. Das, Learned Counsel, appearing for the respondent number 7, placed before the court a copy of the order dated 09/08/2021, passed by a coordinate bench of this court in WPC number 3551 of 2021. Within bracket, Mofur Uddin, MOFUR, then Uddin, UDDIN, versus State of Assam and 5 others. With regard to B.Ed degree obtained by the respondent number 6 therein from said Dr. Sosi Bhushan Institute of Education, formerly known as Hailakandi B.Ed College, Hailakandi, wherein the court, after considering entire aspect, remanded the matter back to the additional secretary to the government of Assam in the secondary education department for his determination. Firstly, whether Dr. Sosi Bhushan Institute of Education had made its application prior to 18.08.1997, and secondly, whether the said institute was in existence as on 17/08/1995, when the NCTE Act came into force, and accordingly pass a reasoned order thereon. Mr. Das, counsel appearing for the respondent number 7, placed a copy of the communication number ASC.112/2020/157, dated 02/06/2022, of the additional secretary to the government of Assam in the secondary education department, whereby in compliance of said order dated 09/08/2021, passed in WPC number 3551 of 2021, considering the report of the NCTE dated 16/11/2021, by which the NCTT clarified that the said Dr. Sosi Hussain such and such, within bracket Hailakandi B.Ed College, Hailakandi, sought for recognition for B.Ed course in the said institute by filing application on 12/08/1997, by submitting application. Right, diary number 4262 oblique, so 4262 dated 21/08/1997. Considering the same and obtaining the views of the judicial department as well as the LR, the additional secretary government of Assam in the secondary education department by the said communication dated 02/06/2022 came to the conclusion that the B.Ed degree of said Mafuruddin, I got the respondent number 6 million question, respondent 6 petitioner question. Mafuruddin, who passed B.Ed degree from said such and such, Dr. Sosi highlighted. During the session 96-97, 1996-97, and passed out in the 1997 is a valid from legal point of view, and that said Mafuruddin, subject teacher, Baleswar Higher Secondary School, Kachar, may be considered for appointment as a regular principal of Baleswar Higher Secondary School, Kachar. However, in the present case, the respondent number 7, in her additional affidavit filed on 30/11/2021, annexed copy of the communication number AUD/9/96/102 dated 05/07/1996 of the Assam University, Silchar, Kachar, by which the director, College Development Council, Assam University, Silchar, informed the principal of Hailakandi B.Ed College, Hailakandi, according its approval to start Hailakandi B.Ed College at Hailakandi for the session 1996-97, subject to the fulfillment of the conditions laid down by the university specified the said communication, specified in the communication of the Assam University, said communication of the Assam University, dated 05/07/1996. The said communication of the Assam University, dated 05/07/1996, to the authorities of Hailakandi B.Ed College, Hailakandi, clearly reflects that only on 05/07/1996, Hailakandi B.Ed College, Hailakandi was permitted to start the said B.Ed College for the session 96-97. Whereas the NCT Act 1993 came into force with effect from 01/07/1995. The said communication of the Assam University, that is 05/07/1996, clearly reflects that on the appointed date of the NCT Act, 01/07/1995, Hailakandi B.Ed College, Hailakandi, was not in existence. From the communication dated 02/06/2022 of the Additional Secretary Government of Assam in the Secondary Education Department, it can be seen that though the court, by order dated 09/08/2021, passed in WPC number 3551/2021, specifically directed the authorities in the Secondary Education Department as to whether said Shashi Bhushan was in existence as on 17/08/1995 when the NCT Act came into force, was not considered. And in spite of that, and without coming into the said finding, issued the said communication number ASE .112/2020/157 dated 02/06/2022. It is also seen that pursuant to the order dated 23/01/2019, next week, the petitioner took steps for service of notice on the respond number 6 by registered post with AD on (28/01/2019), and the same was sent to the respondent number 6, Dr. Shashi Bhushan Institute of Education, B.Ed College, Hailakandi, by registered post with AD under memo number 337 dated 30/01/2019. Office note reflects that till date, neither the AD card nor the answer notice were received by the registry. Registry shall list this matter before the Lojima Court. By 27. 2023. Along with the report of the Lojima Court, matter shall be listed again on 16th of March. बाकी लिखा IA 2155/2020 ऐसा item number 4 along with WPC number 5217/2017 on the prayer of the counsel for the petitioner. It is submitted that Mr. Ayat Sekhar, counsel for the petitioner, is in this court. On the prayer of the counsel for the party matter is adjourned. List on 1603 along with WPC number 4291/2007. Same on. List along with 4291/2017 on 16th. Public.
Both of us we have discussed and noted the in view of the order passed by the court. And that is regarding ragging and all that, lawsuit. We are not on that. And our case is something different. That this is our case is under DAC law. So that's a ragging committee is different. So in the meantime, lawsuit, we may be allowed. And all that lawsuit, we file an appeal. Yeah, giving all the clauses. And they will dispose it of lawsuit. Here it is given 2 weeks lawsuit to dispose of the year. And against that order lawsuit, the law will take it on court. Lawsuit, if it goes against us, we file an only thing. My learned friend has said, so I am filing an appeal, I lose a forum lawsuit because DAC is the first forum lawsuit by the way. In the rule. Anyway, I'll file an appeal, no problem.
Mr. Mazumdar, whether they have to file first appeal or file.
Since the DSC has already passed an order, if lordship directs them to file an appeal because the discipline appeal which allows them to take all those grounds which they have taken, including that the hearing was not fairly done. In case that EC finds that yes, it is correct, which to some extent I admit it is correct, we will give them everything that is to be done. The EC will direct the DAC to give them the full opportunity and come up with a proper report. After which a decision will be taken on what to do. And lots of only one thing, here we had passed a common order. The hearing that was supposedly done was done in a common manner. Here the charge sheet has to be individual to each of the petitioners. The appeal has to be filed by the individual petitioners. The hearing takes place individually whatever fault is found, or the exoneration has to be on an individual basis.
No, we can do one thing. Let the petitioner file an appeal before the authority
No.
with the pointing it out that the DSC did not
That they were
provide.
not even given the memo of charges of the exact charges that was leveled against them. That is what I have received one of the appeals filed by the person, this Galopdeka, the order vigilance. He has made one simple statement that I was not even given the charges. I do not know the evidence against me, and therefore it is wrong. That is what I have advised to the university, that you have to start from
That
zero.
may be kept in open lawsuit. I will take all the
Let-
survey.
let me-
No, that
all
is
the
what,
grounds-
when you file the appeal,
Yes,
you can take all the grounds,
Yes, yes, that may be kept
and then
open.
we proceed with it only to his lordship.
but the appeal is declared filed before the VC,
But before the EC,
Executive Council.
Executive Council.
No, my lord, it is
I am
to the
sorry.
register lawsuit. We have to file
It
it before
will
the
go before the
register.
registrar. The
Register
registrar
will
will
send
place it before the
No,
appropriate.
no. Addressing whom?
Lordship may come to page 37, lordship.
Address to whom?
Page
That's okay.
38, lordship, page 38, 11. Page 38, top of the page 38.
Hmm.
The student may appeal against the item of the DSC to uphold an allegation of the misconduct against the penalty imposed. The appeal must be submitted to the registrar by the student in writing within 7 days of the notification of the decision of the university.
It has to be looked into by the EC. Ultimately, the EC takes care of the whole thing. They'll file it to the registrar.
No, no, it is there.
So we'll place it before the VC,
Go by the-
before the EC.
Okay.
Also, only one thing, my lord, in the other case, it was the case of ragging, my lord, the students can be controlled. Here it is a case of an assault on, alleged assault of the employees of the security personnel. So, my lord, some restriction upon them to, as to how much they would
My
utilize the
lord,
university.
ragging is a serious thing, lordship. Ragging is not that much.
It will be the classes and the library facilities.
Ragging is the highest degree of the lordship punishment otherwise. Ragging is not like this.
But Mr. Sharma, as you know, you are also a father.
No, no, I
Yeah,
do know that.
some students
No, I
are,
am not there. I'm not supporting.
we are not saying these students,
No,
these
Lord,
petitioners,
I'm
but
not
some
supporting.
students
No,
are really.
No, no, I agree, lordship. That
And
is there.
as you know, many parents is to cry
Yes,
for their children. They cannot control.
my son is also studying in an institution outside.
That's right,
lordship,
not all,
so I-
not all. But you know, some really. We studied in the same school.
My lord.
We had a sir. He used to always go by cycle. Our LP school. His son wanted a motorcycle. Poor fellow, a retired LP school teacher, he knows. He sold his property to give a motorcycle to his son. Sir expired. I don't know what son is doing. He had no job.
My father used to tell me two things. One, there's something called a mob mentality. When everybody stands up, do not just walk out of there, because then you are not what you think you are. It is the mob, and you go with it. You cannot
That,
stop
but
yourself.
things are happening because nowadays parents
Nowadays,
cannot control.
no
Yes,
control,
in the
lordship.
hostel, when
Such
everybody
is very
stands up, definitely everybody stands up. Even I have seen hostels. I have been there in Sunday school. I know.
No, I will not
Standing up
say
for hostel is a
about
hostel.
ragging. That is ragging is. the
Ragging is a
issue-
different issue.
Issue, the physical
Here it was
assault
the
is.
administration versus the students. So the students' mentality that I need to support the hostel will come in. This way or that. So there was an incident. We just will find out the appropriate persons.
But
and
when
the
it
appropriate
happens, you
punishment.
know, only a few will do,
Yes.
but along with that, those
Everybody
few,
comes.
there will be many. And if somebody goes and stops him, he'll be best up. Everybody keeps quiet. That's the what happens in a hostel.
On that motorcycle
Some
part.
person are victimized sometimes. lordship.
Some are, we don't know, we will not say anything in that.
Yes.
On that motorcycle part, my lord, I had once asked my father for a motorcycle. He told me, you can ask because your father is a rich man. I cannot have one because my father was not a rich man. So you think whether you need one or not.
So, Mr. Majumdar, that paragraph 7, appeal before the register. Mr. Sharma, give us a time, when, by which time? Today is 21st. By,
28, lordship.
okay, we'll give you some more days. Not. Within 10 days, 3rd of March,
Lordship.
3rd of March, 10 days. If it has file appeal, short kill if it appears my friend. Within 10 days from today, I 03/2023 before the registrar, the Dibrugarh University. Stating his grievances therein. Who in turn shall forward the matter to the before the executive council. Who shall pass the necessary order. How much time dispose of the appeal of the petitioner? So if he files by 3rd of March, 4th and 5th, Saturday, Sunday,
Then we close for the Holi festival. Should give us at least 20 days because the EC members, they are from all over India to circulate it. They have to give their views.
no, here the time limit was given 2 weeks, 1 week,
Yes.
2 weeks, we don't know.
No, that which actually for us, we allow the appeal and give them a fresh hearing is almost a decided point. This is off the record.
So what do you say here?
2 weeks or 2 weeks.
2 weeks
For
will
that,
do?
2 weeks for this 2 weeks.
Okay.
In case we need more time, my lord, we'll move an I before this court to extend the time.
Okay. On receipt of such appeal on or before 03/03/2023. By the register. The Executive Council of the Dibrugarh University within a period of 15 days from the date of its receipt shall dispose of the appeal of the petitioner, intimating him about the outcome of the same. That much.
Could it be expeditiously, preferably in 15 days? My lord? Bind them to some extent.
Okay.
It is the
Preferably from the date of receipt of the appeal by the Executive Council,
Yes.
not by the register. Till such appeal is disposed of by the Executive Council. The impugn order of disqualification from pursuing further studies and prohibition from further admission or readmission in the Dibrugarh University as well as his entry and movement in the Dibrugarh University campus, prohibiting his entry and movement by the order that is such and such 17/11/2022 shall remain suspended. However, it is made clear that during such period from the date of filing of his appeal till such disposal of his appeal, the petitioner shall be allowed to attend the class and the library of the Dibrugarh University. Dibrugarh. But maintaining peace, tranquility and harmony. Any breach of such peace and tranquility by the petitioners the approach of the respondent university. Court shall consider to pass necessary order.
The result, they will give the result also. Because they are
That
CBC.
result, I think so, the division bench has specifically passed.
Yes, the division bench said till the disposal.
There is a difficulty.
Till the disposal of
At least
the.
with the first petitioner, he did not give the in-semester examinations. He
Hmm.
directly appeared in the end-semester examinations. Now, there is a rule which says that without appearing in the in-semester examination, he
Then
cannot
we'll
be
make it
allowed
clear.
to appear to-
If the petitioners have fulfilled the requisite criteria of the examination,
No, it is clear.
their results may be declared in terms of
But
this.
let the appeal be disposed of. Thereafter
No,
the
no,
results
no,
will come.
they are CBS, they
We are
are
not,
own rules.
we are not disallowing them from attending the fourth semester classes. Nothing wrong with that matter. We are not even objecting on that. Let the appeal be disposed of. The results will depend on that.
Lordship may please come there, the 9.3, it is clear, Lordship, they cannot keep it like that, 9.3 of this rule, Lordship, it is their own
It
rule,
is only
Lordship.
because they have not entered the
We'll make it clear.
examination which was not placed before
It
this
is the
court.
CBCS rule up to their own rule, the university rule, Lordship, it is the 9.3.
Mr. Sharma, if it is a fact that the petitioner did not appear in one of the part examinations,
Even then,
Yes.
Lordship, it is there, Lordship, that is
The
what I want.
declaration of the results will not come.
That is
He
what I
will be
want
allowed to
know,
attend
Lordship.
let us see what is there first.
9 point, Lordship may please come to 9.3 first. The candidate who fail or does not appear in one or more courses of any end semester examination up to the semester final shall provisionally promoted to the next semester with the failed courses as carryover courses.
No,
such-
this is,
No,
Mr.
Lordship,
Sharma,
I'm
this
showing
what
this. No.
doesn't
no,
appear
suppose
in one or more courses. We are saying, let us assume there are 7 papers. Right? So did not appear in one paper. That is different issue altogether. But let us
Suppose, Lordship,
assume
it is-
that one of the
Ten point 1.7.
Hmm.
The controller of examinations that declare the result of due CBCS program and issue grade sheet within 1 month from the last date of the examination. It is the rule, Lordship.
But thing is, we don't know, Mr. Sharma. Yes, Mr. Mazumdar.
My lord, there are 2 examinations. One, the appearance in one of which depends on the appearance on the former, the in semester and the end semester. He did not appear in the in semester. That was not informed to this honorable court. And while the matter, when the interim orders were passed, he was allowed to appear in the end semester examination. Had we brought it to this honorable court that he did not appear in the in semester, he would not be allowed to appear in the end semester.
Now, just tell us, is it a part in the rules of the examinations of the university?
Yes, my lord, that one letter I had, I will show my lord. Yes. 8.5.
Lordship will read the 8.
8.11, 8.11.
In semester, yes.
No, 8.11 is 8.5.
8 is the rule, Lordship. I cannot go.
8.2. there shall be at least 2 in-semester assessments and 1 end-semester examination in each course.
Yes, that is what I'm saying.
What had fallen from Lordship 8.1. The examination of all courses shall have 2 parts, in-semester assessment and semester examinations. There shall be at least 2 in-semester assessment and 1 end-semester examination in each course during trimester. The result of in-semester assessment shall be notified to the concerned course teacher within 7 days of the examination. He did not appear in that. 40% of the marks of each course shall be allotted for in-semester
Lordship will say
evaluation
they will
or
follow the
internal
rule
assessment.
And give the result. Is I'm out, Lordship. I take the specific instruction, Lordship. If I'm out of this rule 8, I'm not entitled for a result.
Mr. Mazumdar,
My lord. If Lordship, 8.5 the last line. of the bill.
8.11,
8.11 is 8.5. There's a bold part and there's a normal part. 8.5.
it is also made clear.
It is here. It is written. The in-semester assessment must be completed before in-semester.
that's what
He
we
did
will
not complete.
We will make it from the results of the petitioners. Indically, Mr. Sharma, and a senior counsel appearing for the petitioners, placed before the court the notification of the Dibrugarh University dated 21/11/2018 pertaining to Dibrugarh University regulations for the postgraduate programs in the SOIST-based credit system 2018, along with the relevant rules, where Rule 8 containing the provisions of Rule 8.1 to 8.13 pertains to examination, and Rule 9 containing the provisions from 9.1 to 9.5 stipulates about result and progression. Further, Rule 10 of say 2018 rules relates to evaluation and declaration of results, containing provisions from 1.1 to 1.8 and
That will cover.
the respondent authorities in the Dibrugarh University shall declare the result of the end semester examination in which petitioners appeared pursuant to the order of the court first earlier, shall be declared following the provisions of say 2018.
Refer to 8.4 and 8.5.
We have clarified.
This
We are not, see, we are not experts in that. You are the authorities.
specific
We
statements.
have mentioned about rule
Be
8.
specific, the same rule I am depending upon. 8.4, the last line.
Whole
Students
age
shall
loss.
compulsorily
Why only
attend the 2
8.5?
in-semester examinations,
We'll make it
failing which they will not be allowed to appear for the in-semester examinations.
clear. You are talking about 8.5 or
8.4, last line. They are not supposed to appear even. This was not brought to the notice. In case the appeal is allowed, we'll
At
hold the
this stage,
in-semester.
Mr. Mazumdar, counsel appearing for the respondent, Dibrugarh University, placed the provisions of rule 8.4. 2018 regulations. As well as 8.13 Somewhere said no.
8.4 last line, 8.5.
And 8.5. Where in the rule 8.4 at last, in the last portion of the rule 8.4 of say 2018 regulations, it is stipulated that the students shall compulsorily attend the 2 in-semester examinations, failing which they will not be allowed to appear for the end semester examination. 8.5. No, that is in semester is only in 8.4.
And
Yes.
8.5, the last line, the in-semester assessment must be completed before the end semester examinations. That is
And
not
that
done.
last portion of that in semester assessment must be completed before the end semester examination. That's what we found. The respondent, Dibrugarh University, shall declare the result of the petitioners following the provisions of say Rule 8, all the provisions of Rule 8, 9, and 10 of say 2018 rules. Yes. This point of
It is in dispute of it.
no point of keeping it.
Yes, no.
Hearing.
For hearing item number 9.
Mr. Kash Hazarika. Two things is coming up in my mind. That's what kindly clarify. Now, normally what happens, say, as you know, that if an application is filed before a particular court and it doesn't have the jurisdiction, it either returns the application to the applicant or forwards it to the concerned authority who has the jurisdiction. Say, for example, in the criminal matters, the particular police station is not known under which jurisdiction, because there may be border of one district and the other. Say, for example, somewhere, because assuming Kokrajhar and Bongaigaon, or giving an example. So Kokrajhar and Bongaigaon, Baksa and Nalbari, or Baksa or Borpeta, all these things are there. So if a particular police station, there will be various outposts. So outpost will necessarily forward it to the nearest police station. And a charge sheet will be filed by the concerned police station. On the basis of charge sheet filed by the concerned police station, the concerned court of that particular jurisdiction, territorial jurisdiction, will take up the matter. If it is a sessions case, it will be, say, for example, if it is a sessions case, the concerned district and session judge will take up the matter. If it is in the other district. Now, if a matter, say, for a trial in a criminal matter, the trial court found that that particular police station, the place of occurrence, police station by which the search sheet is filed is belong to that particular district. But the place of occurrence is in a place where the jurisdiction belongs to the neighbor district. Any trial, after knowing it by the district and session judge of that particular court, will be wrong. If it comes to the appeal, if the accused is convicted, he can always come before the court saying that he doesn't have the territorial jurisdiction. So normally what happens, the concerned trial judge, while considering all these aspects, these are the training normally we give in our academy, because many districts has been formed at a later stage. Initially, as you know, Mr. Then district judges will first verify the notifications issued by the Home Department of the state, whether these particular villages belongs to which police station. In many other cases, you will see there will be outpost managed by the ASI. There will not be any OC in those cases. So necessarily they will, what will do, it will going from those records, the district and session judge of one particular district will pass an order remanding matter to the other district, saying that this court doesn't have the jurisdiction because of this government notification, or this place of occurrence falls under the jurisdiction of this district, not in the district where the presently trial is going. So necessarily, again, the accused to be placed before the, on that remand, we ask him to appear before that particular court. That is the system.
Yes.
Right? Now here we have seen that the application has been filed by the applicants under the NH Authority Act, in the section 3G. And it was at no point of time, it was forwarded either to Kala or the arbitrator who has the jurisdiction, the competent authority who has the jurisdiction to proceed under the provisions of the National High Authority Act. At this stage, and as you have seen, that judgment has been placed that any point of time till such decision is taken, even after a review, because if you see what Mr. Borua has placed is a decision by the court in a civil matter. But what we have been pointed out, if there is a territorial jurisdiction issue is there, or the jurisdiction of the court is there, that can be raised even by a review petition. You need not file appeal. When you file an appeal, you have to pay.
Yes, appropriate.
But that is the reason the apex court considered to that aspect that even by filing a review, you can bring it to the notice.
Here, my lord, case is different.
No,
Here
we
case
can
is-
understand that you are asking for damage. Absolutely right.
Yes,
Damage, whatever is entitled by you because of dumping of after the accusation.
and non, and.
To that extent, absolutely correct.
Construction done in the non-acquired land, 4 land,
Whatever,
yes.
either the land was acquired, not acquired, doesn't come, that is a different issue. We are not on that, but you are asking for the damage. But your asking of damage, your application absolutely is on the basis of the provisions of the National High Authority Act. Whether the deputy commissioner, not being the competent authority under the act, could have proceeded with that particular thing, or he could have remanded the matter to the additional deputy commissioner to proceed with the matter. We can find out. That is the reason, Mr. Katharika, this clarification from your, because otherwise you need not go on the merit of the case to that
Which
extent.
on my lord, land in case of a acquired land.
We-
Then competent authority.
You are
will
right,
come.
you are right.
If
So,
land not acquired, my lord,
Hmm.
competent has nothing, competent authority has nothing to do anything. He cannot even do anything.
Then what
for
happened?
Determination of competence.
that is the thing we're saying, that in that case,
When
the
legal.
prayer of the applicant was to give the damages, right?
Damage,
So damages under the provisions of what?
the National Highway Act.
So
So,
any matter, whether it is damage, if you read the 3Z,
it will not
You
go
will
to the
see-
competent authority, my lord.
It
Because
is-
land is to be acquired by the revenue authority.
that is why I'm saying that
And then when it would to be acquired for a particular purpose, then assessment will to be determination will be done by the competent authority matter. This is the law. So otherwise competent authority cannot,
for the purpose of assessing or determination of the damage of land that has not been acquired, definitely,
subsequently acquired here. In 2013 land acquired. And in 2010, my lord, when we have served a legal notice, ATCTC notice, that time land not acquired. And in 2012, my lord, land not acquired. When we have filed a lawsuit, land not acquired. My lord. Land acquired after joint physical verification of the affected land in 2013. My lord. For since 2010 to 2013, no land acquired by.
so the land involved in this particular case
Yes,
was subsequently acquired.
2013 land.
The entire land over which you had the claim,
Yes,
this is the land which was,
after joint verification.
no,
my
no,
lord,
this was,
National
this
Highway-
is the land, this is the land
Yes,
where the damage was caused.
damage caused and 4 land has been
No, ठीक है, which is
constructed
done.
across the 4 village, my lord, revenue village.
the survey was done.
In the
my
which
lord.
year?
Survey was done.
Which year? Which year?
In 2013. And that time, my lord, compensation determined by the highway authority after joint verification of the land, my lord, affected land. So that is why, my lord, where they will go, the remedy will have to be sought for from the civil court for damage. Section 3G said that, my lord. 3G specifically said determination amount payable as compensation where any land is acquired. So land not acquired, land damaged by the National Highway Authority and by the contractor, my lord, Hindustan Construction Company. And reply has been given into the legal notice, clearer notice, my lord. In the reply, my lord, Highway Authority says that contractor is liable. Highway Authority is not liable because contract provision is there. That is the reply of the ATCPC line. When that reply has been received, then where they will go? Where they will go for remedy. So lawsuit has been filed. Deputy Commissioner had directed to survey the land, affected land. Then the Revenue Authority has gone for verification of the land, joint verification of the affected land. Then competent authority comes, my lord. Then they have determined in 2013. So 2010 to 2013 land not acquired. So there is no alternative remedy for the petitioner to approach. Therefore, they approach before the civil court. They claim damage because there is a provision in the National Highway Act for grant of compensation for land. Even the constitutional provision is there, my lord. Article 300A. So nobody can be deprived from property. They are to be given compensation, my lord. So compensation has been awarded. Now they have challenged the order of the Deputy Commissioner. They have not challenged the determination report of the competent authority. This is the case, my lord. So if your lordship will set aside the order of the Deputy Commissioner, even then, my lord, the report of the competent authority by which the determination of compensation done for the affected land, that will remain in force. If they have been agreed because of the determination made by the competent authority, they are to approach before the arbitrator, my lord. It is their duty to appear before arbitrator for redressal of grievances. If it would be treated as a civil suit, my lord, lawsuit, then they are to prefer appeal before the High Court. High Court rule says that any decision made by the Deputy Commissioner, that is appealable before the High Court. And local act is there, my lord. Local act says the Deputy Commissioner in case of land dispute have a right to conduct a case, my lord. Same power has been given to Deputy Commissioner and additional Deputy Commissioner by the local action rules. I have filed my affidavit in opposition. I have annexed some documents, my lord. That documents they have not annexed with their petition. They have suppressed, concealed, and material fact before your lordship. And the document says that everything.
Now,
has been
Mr.
done.
Borua,
My lord.
when this land was acquired in the year 2013, how much compensation you have given to the petitioners?
Yes, my
The
lord.
compensation not given. It is only determined.
Is that land subsequent affidavit has come, my lord, which reply to given, yesterday I have not brought. So today, already they have received the amount.
No, that is the first equation.
There is a no, not second equation. There is not at all because
No.
we have already replied to this affidavit. Here, my lord, report.
No, the thing is the recent affidavit of the Revenue Authority of this
Yes,
particular
that is
district.
what it is been said.
They said that the land has not been acquired.
Acquired. Land has been acquired. That is
Is it
also
a fact that
That-
it is true that land has not been acquired?
not acquired here. Procedure is, my lord. Even,
You cannot go beyond whatever you have said in
so
affidavit.
my lord, one I am submitting on
Question is,
this
my lord, they have
regarding how this being constructed, my lord.
No, no, let us see that. whatever the land that was required for construction of the national highway,
Yes.
by notification, you have annexed and
TATD.
annexed it,
That's,
and
so we have paid accordingly.
you have paid
Uh.
whatever land that has been acquired.
But here,
And for that purpose, the competent authority has already determined, you have paid, it was
Paid the
received by
amount.
them.
here, your lordship, even their own application, it is saying that due to damage, dumping and all the things. This one, where we are saying in reply that dumping in beyond ROW, that is whatever land is required, that comes under ROW as your lordship award, that before, after that, it will be beyond ROW.
They have
Whatever
submitted-
damage is caused, that is to be done. Here, our PRI before your lordship, your, as rightly your lordship have pointed out, because once you are asking, let it be, because he may be correct, he may not be compensated properly. That is, I'm not on that, my lord. My point is there, once you are filing under the provision of NHS, in now, just now my learned friend has submitted that under 3G, where will go? Because you have to go to 3G of what? NHS. What 3G? 3G will, 5 will come first. If you are having any grievances, but either parties can go to arbitrator. Arbitrator, either party, even NSA also can go. But here the question, we are not affected. They are the affected person. That is why they have filed the application. But what happened, my lord? Problem is where? Here problem is there. It would have been by arbitrator. Same thing. Same order written by arbitrator. We do not have to say anything, my lord. But who is he not having jurisdiction? And your lordship very first line pointed out, DC here only under DSEC, two persons, rather two posts are mainly involved here. One is Kala, another is an arbitrator. There are two things. One is Kala will, because TA as well as TL, Kala will be appointed Kala. And we are always demanding the land to the Kala, that is known itself competent land acquisition authority. We are demanding to land acquisition, and procedure has been floated. Thereafter, we are, as per demand of Kala, we are paying the depositing amount to the Kala. In turn, Kala has paid, will pay the amount. Those checks are signed by both the parties. That is here. Now he being aggrieved, he has filed my lord application under 3G. And he said, this is nowhere at all. Where it is, in this particular post, he is a stranger. Once who is not having jurisdiction, suppose he is passing order, it is null and void. He doesn't have power even to go beyond that. Why it is being done? I'm putting questions to myself, my lord. Once I do not have power to us to defend the case on behalf of NSA. Tomorrow, anything order passed, it will be valid. For example, one thing which I'm just joining, I have joined in practice. I have seen one judgment was very good judgment was delivered on person, but argued by one senior counsel, he was not in record. That was being challenged. That was the challenge. Ultimately, division bench set aside. Why? Because the man who is arguing or who has defended the case, he is not on power. That is why, like this even will be gone that Supreme Court clearly says, very simple analogy, my lord, if we do not go by court of law, once I do not have power, now, like your lordship pointed out, criminal case is to be given now civil court. Now civil judge will drive this one. Civil cases will be direct criminal manner. Session judge will this one or criminal case, but session judge case is in civil court. When his capacity of district judge only he has to argue the matter, he has to say this one the matter, civil matter. But when a session judge, he has to do criminal cases in the capacity of session judge. Like this, once he doesn't have power, my lord. He doesn't have power to entertain even this case.
My lord, they have.
That is why my
submitted a
submission
list,
I am
my
leaving
lord.
to your lordship. We are not going beyond that. Even it is, I have filed an affidavit that land in question already been acquired, road is being constructed, and on same land, we cannot change also, my lord, there is a procedure. We cannot change the land. Once DPR is there, for changing DPR, which no one can change it, DPR. First government will take decision for construction of 4 lane or any road. Thereafter DPR will be there. After DPR, if this sanction, then a procedure, land acquisition procedure will be there. Thereafter, we are paying amount. Thereafter, land is handed over by Kala. Thereafter, this one, we cannot go, simply cannot make the route, my lord. This allegation is false allegations, vague allegations. Beyond DPR, we cannot go, my lord. Otherwise, whoever false, why Jaji action is there, my lord? Why CBI case is Jaji to Dibrugarh only because of this? What happened, my lord? There, what happened? In DPR, supposed to be 100 meters both sides. What happened? One side, Mandal and Lakmandal and circle officer, they have side one side, they have taken 80, another side 120. They make it by duty. Then when they come to know, it is only a DESCAM has come up. We cannot go beyond, my lord. That is not at all. DPR, beyond DPR, we cannot go. Here, the question is not there. Only question is before your lordship. Now, in my humble submission and prayer before your lordship, that if whether ADC has power or not to adjudicative matter, this order. Is if he has power, if your lordship is satisfied, if he can satisfy, then I want no one to say. But in my view, ADC doesn't have power, jurisdiction under the law of National Highways Act 1956, my lord. In no way DC word is coming here. You were filing application. Very beginning, I told you would have been arbitrator. You go arbitrator. The 3G who I have filed before us. The lordship taken now it could have been shifted to arbitrator. Because now
One
he is
thing,
telling
my
why
lord,
the
it is-
NSA has not gone arbitrator. I have not filed application before the
It is
ADC.
a right time to
Right, my
reflect
lord,
it
my lord,
before your lordship,
I have
my lord.
not filed application
They have
before the ADC,
submitted the
DC.
list, my lord.
He has filed the
List
application
of
under
person,
3G. That
those
is to whom
who
supposed to be
receive
filed.
compensation, my lord. They have
Once
annexed
you do
some documents by
compensation,
which they are reflecting that some person has received compensation. Repeatedly, they are saying before this court that these persons are receiving compensation to whom compensation is awarded by the court.
Why?
Not that, my lord. If your lordship will come to page 24, my lord. Page 24 of the writ petition, my lord. Here, some person's name has been reflected, but name
Here-
of those persons not there in the judgment delivered by the trial court, by the civil court, my lord.
here,
The persons are different, my lord. They are saying we have already given compensation to the affected persons, but these persons are not been given any compensation, my lord.
oh,
That they are
Yes.
listed, they have given a list for Longpur, village Longpur, Kalimdisa, and without it. Repeatedly, they are skipping. They are skipping and says that these persons who has been awarded compensation, they have already received compensation. This is a false statement made before this court, my lord. What is right, that is to be reflected honestly before the court for getting justice, my lord. He is in the court and trying to mislead the court. The person who did not receive any compensation for their land, saying that this person has received compensation, list they have given to the repetition. Is it, my lord, correct? Wrong statement made before the court. After all, they should have to respect the court. Honestly, they are to reflect all documents before
Mr.
the court.
Kathazari, just tell us one thing. This, can you show us on 2013, which part of the land was acquired by the National Highway Authority?
That I have annexed.
Do you have any such notification? Because as you know that for the purpose of acquiring, it has to come village wise. Have you annexed at any point of time? During,
It is a revenue made survey, joint
No.
survey made with the affected land, my lord. That is
That
your
is-
lordship. I am coming to my debt,
no,
my
no, that's
lord.
what we want to.
I am
know,
coming
whether
to that, my lord.
that
Page
survey-
30, page 30 of my affidavit, my lord. Affidavit in opposition, page 30, annexure B7.
30.
B7. It is joint verification. NIA, National Highway Authority, PWD, and other revenue authority, they are present in the time of fresh survey of the affected land. Page 30, my lord.
Of your affidavit in opposition?
Yes, yes, my lord. Annexure B7. The person whom the person name of the person which has been reflected in the assessment report. All those persons did not receive any compensation. Repeatedly, they are saying this person have already received compensation. They are claiming additional compensation. These are the words they are using every day, my lord, yesterday, today also, even also. Rightly not reflected that everything. They have made a statement that they have already given compensation to this person. It is wrong statement, false statement, misleading that the court. The page 30, my lord, here survey has been made by the National Highway Authority, PW Authority. They have admitted all the land has been affected. Their land has been used by the enclosed by the National Highway Authority. They have constructed National Highway 4-lane, my lord. This is the reason, my lord. That is why determination survey was done. After that, my lord, compensation was determined. After land acquired. Now your lordship may come to page 34.
Hmm.
Page 34, it is a information made by the competent authority to the court, my lord.
Hmm.
30th July of 2013. So on that day, it is informed to the court that land acquired. Now, last para of that particular. Further, it may be pertinent to mention that the land is required to be due to diversion of alignment while fixing right of way by the contractor engaged by the National Highway. The additional land is acquired under Synergy Matriva. It is also fact that the consultant engaged by the never consulted with the revenue official directed the fixation of right of way. It seems that they have the right of way as per their convenient consideration. So land acquired subsequently in 2013, my lord. So at the time of filing of the lawsuit, my lord, land was not acquired. How the compensation will be determined by the competent authority, my lord, under the provision of the section 3G? Then the person whose name reflected, your lordship may kindly see next page 35. Longpur village, my lord. Some persons, there are 17 persons' name has been mentioned here, my lord. All persons, their name not available in the annexer, they have placed before your lordship in the writ petition. Now, repeatedly, they are saying this same person has received compensation twice. They've been given compensation. Again, compensation awarded to them by the court. Not that, my lord, they have not received any compensation for their affected land. It's too much, my lord, they have done wrong. They should not do before the High Court, my lord. At least before the High Court, my lord. It's the lower court practice, my lord. I have experience on that, my lord. These persons, Kalampur, then your lordship will come to Kalim Disha, Didaudi. Their name not available in the record they have placed before that your lordship by filing the petition, my lord. They have filed written statement. Even the written statement, they have not reflected, they have already paid compensation to the affected persons. They have not raised any objection for determination of compensation. If your lordship will go to Annexure A of my affidavit, my lord. Annexure A, what is their statement before the civil court, my lord? Annexure A is the documents before passing of the judgment. It is an order passed by Deputy Commissioner, my lord. They have been given to go through the report of the competent authority by which the determination of compensation has been done for payment of compensation. In spite of that, my lord, they have filed its petition challenge. Local action rule says that, High Court rule says that if any order passed by the Deputy Commissioner in a suit, dispute, in regard to land dispute controversy between tribal and non-tribal, the Deputy Commissioner have a right to deal with the suit, my lord. Then decision of the Deputy Commissioner is to be challenged by preferring appeal before the High Court. This is the law, my lord, settled position of law. I have a reflected a Supreme Court case, my lord. In my affidavit, I have pointed out index of authorities I have submitted. Your lordship may kindly see my affidavit in opposition, page 5, para 6. Para 4, last paragraph, my lord. of my affidavit in opposition, it is pertinent to mention here that the writ petitioner had challenged that the judgment and order 4/10/2013 passed in mid-J case number 20 of 2012 by the competent regional court at Hapong, which has been preferred by the deponent for civil remedy for recovery of pecuniary damage by filing instead civil totally ignoring statutory appeal as provided in the Assam Autonomous District Administrative Justice Act and rules, as well as Assam High Court jurisdiction over District Courts Order 1954. So it is absolutely clear that when a statutory forum is created by law for redressal of grievances, writ petition should not be entertained ignoring such statutory dispensations as reported in 2014, Volume 1, SSC 603. So there is a verdict of the ruling of the appeals court. When there is a statutory provision, one must have to go with that provision for
Mr.
preparing appeal.
Kathazarika,
Yes, ma'am.
please come to page 33. Now,
Yes,
anyway. This page 33,
Yes, enclosed, land enclosed by a national highway,
no,
Langkur Dalim Disanega. So assessment of properties.
this is
So
in the year 2006,
no, my lord, it is
page 33,
13, my lord, 2013.
33 of the writ petition.
Oh. $33 million.
These are the plots of the respective village that was acquired under the,
Yes, it is,
Right.
yes. This not land belong to this claimant, my lord.
Hmm.
These are different land, my lord.
No, it's okay, just listen.
In the Haflong, my lord, villages are very big one, my lord. In our Assam, my
Now,
lord, villages are,
just tell us one thing. Annexure 6, page 34.
yes, man, that is a claim, my lord.
That
It
is
a
your claim.
Yes, it is a claim, my lord.
It is the claim. That's
It
right.
is inquiry conducted on the basis of
No,
this
no,
claim,
no.
my lord.
This is your claim.
Yes. Then
Now,
picture has come different. my lord.
no, no. This is your claim.
Yes, when inquiry made,
No, we want to know from you,
yes,
because since it is your claim,
yes.
this claim pertains to which land? Where is the schedule of the land on which you are claiming such damage?
It is village mention I have, my lord.
No, no,
Village
will
I
not,
have mentioned.
village will not
No,
do.
inquiry is to be done, my lord.
Village will
it
not
is,
do
my
because
lord,
this is
in
your
the-
land.
Here,
Where
my
is the
lord,
schedule of the land?
schedule of the land.
Where
Sir,
is the
my
schedule
lord,
of the land?
CPC is not applicable.
We are not asking about CPC. Then
This-
where is the question of plot? You have a plot.
Plot, you are mentioned that the name of the village, my lord. Name of the village is Longpur, Kalimdisa and Gidaudi.
Now,
And
just
it
tell
is a
us.
case filed by the Khunang, that is head of the village man, my lord.
Hmm.
So according to this claim, my lord, inquiry conducted, PWD authority, National Highway Authority and Hindustan Construction Company and other authorities, they have visited the affected land, my lord. And then determination of land acquired, my lord. So nothing wrong, my lord. There is a provision in the Haflong, my lord. Revenue authority have a right to make a fresh survey. The civil court has directed the revenue authority and all other authorities to make a fresh survey of the affected land. Then, my lord, things come out, actual truth come out, my lord. Initially, we have no idea about it, my lord. What will be the result come out in future? So when inquiry conducted, then many things has come, my lord. Now,
Okay.
when we have filed a writ petition, they have even also in the writ petition, they have reflected that the person to whom compensation awarded by the civil court, they have already received compensation. This is the their stand, but it is happened on the face of the record. These persons, they have not received any compensation from the National Highway Authority. They are different person and these are the different person. So our claim is a fresh claim, my lord.
Hmm.
Our claim is a fresh claim and our land acquired in 2013.
Lekha. Heard. Mr. C. Burrell, learned counsel appearing for the
petitioner. Petitioner,
petitioners.
petitioner.
Petitioners, National Highway Authorities.
My-
Also heard. Mr. Kikonikor, Standing Counsel. Dima Hassau, Autonomous Council. Respondent number 1 to 1 to 5. 1 to 5. You will appear for 1 and 5. 1, 2, and 5. Come on. MS Didas Bowman, Government Advocate Assam for the respondent numbers 3 and 4. 3, 4, and 6.
6, 7, 9, 9.
And Mr.
7,
DCK
8,
Kat Hazarika
7.
for the respondent number 7, 8, 9. Placed on 15th of March.
My lord,
For necessary.
beg apology, my lord. 15th, I've been not able to rowing March 16th or 17th. 17th, my lord, your lordship convenience.
17 we do not know.
Because 15th I'll be out of station, my lord.
In that case, we will make it on
20, next other week.
21st.
21st, my lord. I'll place. March, my lord,
21st
March.
March.
Right.
Judgment might will come up.
I'll apply, my lord. And your long hearing cases is over.
Let us see what it comes.
No, we think it is over.